Unit 2, Property Ownership and Interests. Learning Objectives. When you have completed this unit, you will be able to accomplish the following. Explain the concept of the bundle of legal rights, the characteristics of real estate, including riparian rights, and all types of fixtures, and you will be able to identify items that may or may not be fixtures by applying all parts of the total circumstances test. Identify different types of freehold estates. Distinguish between forms of concurrent and common interest community ownership. Describe the purpose in different types of trusts. Key terms: accretion, agricultural fixtures, air rights, appurtenance, avulsion, bundle of legal rights, common elements, common interest community ownership, concurrent ownership, condominium ownership, cooperative ownership, doctrine of prior appropriation, emblements, erosion, fee simple absolute, fee simple defeasible, fee simple determinable, fee simple with condition subsequent, fixture, freehold estates, fructus industriales, fructus naturals, future interests, homeowners association, homestead, improvement, improved land, improved lot, joint tenancy, lateral support, life estate, life tenant, limited common elements, literal rights, manufactured home, marital life estate, modular home, non-freehold estate, North Carolina Condominium Act of 1986, North Carolina Uniform Commercial Code, probate, proprietary lease, per order vi, reliction, remainder interest, remainderman, reversionary interest, right of survivorship, riparian rights, severalty, subjacent support, subsurface rights, surface rights, tenancy by the entirety, tenancy in common, timeshare ownership, total circumstances test, townhouse ownership, trade fixture, trust, waste, learning objective. Explain the concept of the bundle of legal rights, the characteristics of real estate, including riparian rights, and all types of fixtures, and you will be able to identify items that may or may not be fixtures by applying all parts of the total circumstances test. The concept of property. The unique nature of real estate has given rise to a distinctive set of laws and rights. Even the simplest of real estate transactions brings into play a complex body of laws, and brokers must understand not only the effect of these laws, but also how the laws define real property. The concept of property, a bundle of legal rights. In Unit 1, real property is defined as land, the improvements thereon, and the interests, rights, and benefits of ownership. It is also often described as a bundle of legal rights. This is a legal relationship between the owner and the property. In other words, a purchaser of real estate is actually buying the rights of ownership held by the seller. The rights of ownership include the right of disposition, right of enjoyment to use in any legal matter, right of exclusion, right of possession, and right of control. Bundle of legal rights. The concept of the bundle of rights comes from Old English law and a population that, for the most part, could not read or write. Therefore, a seller transferred property by giving the purchaser a bundle of bound sticks from a tree on the property. This process was referred to as a livery of seisin. The purchaser who held the bundle also owned the tree from which the sticks came and the land to which the tree was attached. Because the rights of ownership can be separated and individually transferred, the sticks became symbolic of those rights. Appurtenances. An appurtenance is defined as a right or privilege that goes with the ownership of land. Examples of these rights include subsurface rights, air rights, and water rights. A land may benefit from an appurtenant easement that will be discussed in Unit 3. An improvement to the property, whether utility lines or a residential dwelling, is also considered an appurtenance. The protective benefit of restrictive covenants also runs with the land like other appurtenant rights, and will be covered in Unit 6. An appurtenance is generally transferred with the property when it is sold to the new owner. Improved land versus improved lot. The terms improved land and improved lot could have different meanings. Often, these terms are used synonymously. However, improved land usually refers to land that has a structure on it. For example, a house. An improved lot usually means that certain basic required services necessary to utilize it are available, such as electricity, telephone, street access, or water access. An improvement may refer to buildings, fences, sheds, or services such as those mentioned, and these are often considered appurtenance rights. Subsurface and air rights. Surface rights are simply the rights to use the surface of the earth. However, real property ownership also can include subsurface rights, which are the rights to use the space below ground level and to extract the natural resources lying below the Earth's surface. Such natural resources might include minerals, coal, gas, oil, or water. A transfer of surface rights may, however, be accomplished without the transfer of subsurface rights. For example, a landowner could sell the rights to any oil and gas found in the land to an oil company. A landowner then could sell his remaining interest. After the sale, the new buyer would own all the property except the oil and gas rights, which would be held by a third party, the oil company. The rights to use the air above the land also may be sold or leased independently of the land. Such air rights are an increasingly important part of real estate, particularly in large cities, where air rights over railroads have been purchased to construct huge office buildings such as the Pan Am Building in New York City and the Merchandise Mart in Chicago. To construct such a building, the developer must purchase not only the air rights but also numerous small portions of the land's surface for the building's foundation supports, called caissons. Until the development of airplanes, a property's air rights were considered to be unlimited. Today, however, the courts permit reasonable interference with these rights, such as those necessary for aircraft, as long as the owner's right to use and occupy the land is not unduly lessened. Governments and airport authorities often purchase air rights adjacent to an airport to provide approach patterns for air traffic. With the continuing development of solar power, air rights, more specifically sun rights, have been redefined by the courts. They consider tall buildings that block sunlight from smaller solar-powered buildings to be interfering with the smaller buildings' sun rights. In summary, one parcel of real property may be owned by many people, each holding a separate right to a different part of the real estate. These rights may be severed by separate conveyance. For example, while highly unlikely, there could exist, at the same time, an owner of the surface rights, subsurface gas and oil rights, and air rights, water rights. One of the interests that may attach to the ownership of real estate is the right to use adjacent bodies of water. Riparian rights are granted to owners of land located along the course of a river or stream. Such an owner has the unrestricted right to use the water, provided such use does not harm owners upstream or downstream by interrupting or altering the flow of the water, or by contaminating it. In addition, an owner of land that borders a non-navigable waterway owns the land under the water to the exact center of the waterway. In North Carolina, the ownership of water and the land adjacent to it is determined by the doctrine of riparian rights. Land adjoining navigable rivers is owned only to the banks of the river in North Carolina. Navigable waters are considered public highways on which the public has an easement or a right to travel. Riparian rights. Closely related to riparian rights are the literal rights of owners whose land borders oceans and large, navigable lakes that have a tide. Owners with literal rights enjoy unrestricted use of navigable waters, but own the land adjacent to the water only up to the mean high water mark. All land below this point is owned by the government. This makes a portion of every beach in North Carolina a public beach under the public trust doctrine. Western states follow the doctrine of prior appropriation rather than the riparian doctrine of water use. Prior appropriation doctrine states that water rights are determined by priority of beneficial use. This means that the first person to use water or divert water for a beneficial use or purpose can acquire individual rights to the water. Thus, property owners may have land that borders water, but no rights to use that water. Literal rights. Riparian and literal rights are appurtenant to the land and cannot be retained when the property is sold. This means that the right to use the water belongs to whoever owns the bordering land and cannot be retained by a former owner after the land is sold. The boundaries of land can be affected by the natural action of the water. An owner is entitled to all land created by accretion, or a gradual increase in land resulting from the deposit of soil by the water. If water gradually recedes or disappears permanently, new land is acquired by reliction. Erosion, the gradual wearing away of land caused by flowing water or other natural forces, may cause an owner to lose land. When a sudden act of nature such as a flood or avalanche removes soil, this is known as avulsion. Loss of land by avulsion does not change the property boundaries, so the owner has the right to reclaim the lost land. Support rights. The owner of real property has the right to lateral support, or the right to have adjacent property support the natural boundaries of the land. Therefore, construction or excavation on a neighboring property should not cause the soil on the owner's property to subside. As discussed previously, occasionally the landowner severs the subsurface rights from the land and sells them. In such a situation, the property owner is entitled to subjacent support for the surface of the property from the owner of the subsurface rights. As an example, any underground mining projects must assure continued support of the land's surface. Pertinent rights also include the benefit of any easements and protective covenants. Real property versus personal property. As discussed in Unit 1, real property is defined as the land, everything attached to the land, and everything appurtenant to the land. Personal property is defined as everything that is not real property. While the distinction between real and personal property is important to all real estate transactions, it is not always obvious. For instance, is a pile of lumber in the backyard of a house personal property or part of the real property? What about the drapes or an antique mirror attached to the wall of a home? If these items are considered personal property, they can be taken by sellers when they move out of the house. On the other hand, if these items are considered real property, the buyer becomes their new owner and the sellers cannot remove them. Real estate brokers must be careful to see that both parties to a real estate transaction understand clearly which items are real property and which items are personal property to prevent confusion and disappointment at closing. This is best achieved by reviewing the sales contract to see how such items are characterized. Plants. Plants generally fall into one of two classes. Trees, perennial bushes, and grasses that do not require annual cultivation are considered real property. Annual crops, such as wheat, corn, vegetables, and fruit, are known as emblements and are generally considered personal property. In a lease situation, a tenant may re-enter the land after lease termination, if necessary, to harvest crops that result from the tenant's labor. But in a sales transaction, if an annual crop is growing, it will be transferred as part of the real property if no special provision is made in the sales contract. It is possible to change an item of real property to personal property by severance. For example, a growing tree is real estate until the owner cuts down the tree and thereby severs it from the earth, or an apple becomes personal property once it is picked from a tree. Severance also may be the result of a contract. For example, if the owner of an apple orchard sells the apple crop while it is still ripening on the trees, the crop has been severed even though it is still physically attached to the trees. It is also possible to change personal property into real property. If a landowner buys several azalea bushes, fertilizer, and mulch to landscape the front yard, the component parts, which were originally personal property, are converted into real property once planted and applied. They have become permanent improvements on the land. This process is called annexation. If a property owner buys a ceiling fan at the local lighting store and installs it in their family room ceiling, the ceiling fan was originally personal property and, once installed, is converted to real property. Conversely, if the property owner removes the ceiling fan from the family room ceiling, then it would be considered severance. Fixtures. In considering the differences between real property and personal property, it is important to be able to distinguish between a fixture and personal property. An item that was once personal property but has been so affixed to land or a building that the law construes it to be part of the real estate is a fixture. Examples of fixtures are heating plants, elevator equipment in high-rise buildings, kitchen and bathroom cabinets, light fixtures, and plumbing fixtures. If an item is a fixture, it automatically transfers with the property unless excluded by either party to the contract. As a matter of fact, almost any item that has been added as a permanent part of a building is considered a fixture. Legal tests of a fixture. The total circumstances test is a legal test applied by the courts to determine whether an item is a fixture or personal property. All four parts of the test must be applied, but intention is the major part of the test. These four tests are easy to remember by using the mnemonic IRMA. Intention of the annexer: did the person who installed the item intend it to remain permanently or be removable? Relationship of the annexer: is the person making the attachment an owner or a tenant? It is presumed that an owner intends a permanent attachment, while a tenant intends a temporary attachment. The greater the legal relationship the annexer has to the real property, the greater the likelihood the item will be declared a fixture. Method of annexation: how permanently was the item attached? Can it be removed without causing damage? To what degree has there been customization of the space around the item? For example, built-in refrigerators and microwave ovens are often surrounded by cabinetry, making them more likely to be considered a fixture. Adaptation to real estate: has either the item or the property been tailored to facilitate working together? Has it been customized or built into the property? For example, if a gas station owner sells his business, it would be the buyer's expectation that the underground gas storage tanks would remain with the property since the tanks are necessary for the business to function. Although these tests seem simple, court decisions have not been consistent regarding what constitutes a fixture. Articles that appear to be permanently affixed have sometimes been held by the courts to be personal property, whereas items that do not appear to be permanently attached have been held to be fixtures. In the sale of property, the one certain way to avoid confusion over the nature of an article is for the parties to enter into a written agreement that establishes which items are considered part of the real property. A real estate broker should ensure that a sales contract includes a list of all articles of personal property and fixtures that are being included in the sale, particularly if there is any doubt as to whether they are permanently attached fixtures. Articles that might cause confusion include freestanding appliances, invisible fencing and controls, light bulbs, above-ground pools, and swing sets. Brokers should refrain from entering statements such as is listed in MLS hash, or as present in property on in the personal property section, as such statements are too vague to protect the party's interest regarding an article of personal property or a fixture. In practice, the North Carolina Bar Association, North Carolina Association of Realtors 2T offer to purchase and contract lists items that are deemed fixtures: alarm and security systems for security, fire, smoke, carbon monoxide, or other toxins with all related access codes, sensors, cameras, dedicated monitors, hard drives, video recorders, power supplies, and cables, doorbells, chimes. All stoves, ranges, ovens, built-in appliances, attached microwave oven, vent hood, antennas, satellite dishes and receivers, basketball goals and play equipment, ceiling and wall-attached fans, light fixtures, fireplace insert, gas logs or starters, attached fireplace screens, wood or coal stoves, floor coverings, fuel tank, whether attached or buried, and including any contents that have not been used, removed or resold to the fuel provider as of settlement. Note: seller's use, removal, or resale of fuel in any fuel tank is subject to seller's obligation to provide working existing utilities through the earlier of closing or possession by buyer. Garage door openers with all controls. Generators that are permanently wired. Invisible fencing with power supply, controls, and receivers. Landscape and outdoor trees and plants, raised gardens, landscape and foundation lighting, outdoor sound systems, permanent irrigation systems and controls, rain barrels, landscape water features, address markers, mailboxes, mounted package and newspaper receptacles. Mirrors attached to walls, ceilings, cabinets, or doors, all bathroom wall mirrors. Storage shed, utility building. Swimming pool, spa, hot tub. Solar electric and solar water heating systems. Sump pumps, radon fans, and crawlspace ventilators, dehumidifiers that are permanently wired. Surface mounting brackets for television and speakers, recess-mounted speakers, mounted intercom systems. Water supply equipment, including filters and conditioning and softener systems. Recirculating pumps, well pumps and tanks. Window, door blinds and shades, curtain and drapery rods and brackets. Door and window screens and combination doors, awnings and storm windows. This section of the form also permits the parties to negotiate additional items, to delete items which the seller does not wish to include, and to accept any items that are not owned or may be leased by the seller. The seller also declares that the items that are included as fixtures are free of liens. In another section of this contract, the seller is required to remove unwanted personal property and other debris at closing. Activity. Apply the total circumstances test to predict how a judge might rule if this issue went to court. A property owner has solar panels attached to their roof. The property owner lists their property for sale and enter into a contract with a buyer that states that the solar panels are not included with the property, and the seller will remove the panels before closing and repair the roof. If the buyer were then to object to the removal of the solar panels, would the buyer have any standing in court? Activity. Answer. According to the definition of fixture, the panels would be considered a fixture, but the seller and buyer agreed that the seller could remove them before closing. Therefore, the panels would be considered personal property. Activity. Apply the total circumstances test to predict how a judge might rule if this issue went to court. A property owner pours a concrete pad in their backyard and bolts a new storage shed to the concrete pad. Later, the seller goes under contract to sell their property, and the contract does not mention the exclusion of the new shed. The seller removes the shed from the concrete pad before closing and moves it to their new house. After closing, the buyer is surprised to find that the seller has taken the new shed. Would the buyer have any standing in court? Activity. Answer. In this case, the new shed is a fixture and should have remained on the property because it was not expressly excluded from the contract. Trade fixtures. An article owned by a tenant and attached to a rented space or building for use in conducting a business is a trade fixture or a chattel fixture. Examples of trade fixtures are bowling alleys, store shelves, bars, and restaurant equipment. Do not confuse trade fixtures, items a commercial tenant installs to further the tenant's business, with upfits, such as walls or sinks installed by the landlord while preparing the property for the tenant's occupancy. Trade fixtures differ from other types of fixtures in 3 ways. Fixtures are part of the real property and belong to the owner of that property. Trade fixtures are usually owned and installed by a tenant for personal use and remain the tenant's personal property. Fixtures are considered a permanent addition to a building, but trade fixtures are removable. Trade fixtures may be attached to a building in the same manner as other fixtures. However, due to the relationship of the parties, the law gives a tenant the right to remove trade fixtures, provided the removal is completed before the term of the lease expires, and the rented space is restored to approximately its original condition. Because fixtures are legally construed to be real property, they are included in any sale or mortgage of the real property. Trade fixtures are not included in the sale or mortgage of real property except by special agreement because they are considered to be personal property of the commercial tenant. Trade fixtures that are not removed at the end of the lease become the real property of the landlord. Acquiring the items in this way is known as accession. Example: a pizza parlor leases space in a small shopping center. The restaurateur bolts a large iron oven to the floor of the unit. When the pizza parlor goes out of business or relocates, the restaurateur will be able to remove the pizza oven if the bolt holes in the floor can be repaired. The oven is a trade fixture. On the other hand, if the pizza oven was brought into the restaurant in pieces, welded together, then set in concrete, the restaurateur might not be able to remove it without causing structural damage. In that case, the oven might become a fixture. Agricultural fixtures. There is a special class of fixtures in North Carolina called agricultural fixtures. While fixtures used in a farming operation would seem to fall into the category of trade fixtures, agricultural fixtures are considered real property rather than personal property. Therefore, in North Carolina, if a tenant farmer installed feeding troughs during the tenancy, they would be considered real property and could not be removed by the tenant at the end of the lease without special written agreement. Effect of the North Carolina Uniform Commercial Code. All brokers should be aware of the effect of the North Carolina Uniform Commercial Code on fixtures. According to the UCC, if a homeowner purchases an item on credit and gives the creditor a security agreement, that item remains personal property and may be removed by the creditor in the event of default. When the item has been paid for in full, it becomes real property. Suppose the homeowner decides to sell her home before the dishwasher has been paid for. She could remove the dishwasher when she moves out of the house because it is still her personal property. On the other hand, she may leave the dishwasher behind and the buyer might assume that it is real property that was included in the purchase price. The buyer may be surprised to learn that he must pay the secured creditor the outstanding balance, or risk having the appliance repossessed. All home buyers should make sure there are no security agreements filed on items within the home. This is normally included in the title search, which the buyer's lawyer will perform. The filing of the security agreement in effect makes the potential fixture an item of personal property until it is paid for in full. Watch the video to learn more about fixtures. Manufactured homes versus modular homes. A manufactured home is built according to the United States Department of Housing and Urban Development construction standards and is defined by North Carolina General Statute S. 143-143.9 as a structure transportable in one or more sections, which, in the traveling mode, is 8 feet or more in width or is 40 feet or more in length, or when erected on site, is 320 or more square feet, and which is built on a permanent chassis and designed to be used as a dwelling with or without a permanent foundation when connected to the required utilities, and includes plumbing, heating, air conditioning, and electrical systems contained therein. A manufactured home, sometimes referred to as a mobile home or house trailer, can be either personal property or real property. While the manufactured home is still mobile with its own wheels and chassis, it has a vehicle identification number registered with the North Carolina Department of Motor Vehicles and is considered personal property. Manufactured housing is not considered real property just because the unit was placed on a residential lot. To convert the home into real property, the moving hitch, wheels, and axles must be removed and the unit must be attached to a permanent foundation on land owned by the owner of the manufactured home. Once the owner files an affidavit confirming the aforementioned actions, the home is considered real property and an improvement to the lot. Manufactured buildings, which include single-family modular homes, are governed by North Carolina General Statutes S. 105-164.3 and S. 143-139.1. These units are constructed in factories off-site according to state building codes and contain a state inspection label with serial numbers certifying compliance. Once the modular home is assembled on the home site, it is immediately considered to be real property. Brokers should be able to differentiate between manufactured homes and modular homes when listing or selling such properties. The mandatory compliance labels from HUD for the manufactured housing and from the state for modular housing are usually found on the back exterior of the unit, under the kitchen sink, or near the electrical power box. Some older subdivisions have restrictive covenants that prohibit house trailers, mobile homes, or manufactured homes but do not strictly prohibit modular homes. Here are some examples of modular homes, including one under construction. Brent Allison, CC by SAW 4.0 https://creativecommons.org/licenses/ by SAW divided by 4.0 via Wikimedia Commons. Brent Allison, CC by SAW 4.0 https://creativecommons.org/licenses/ by SAW divided by 4.0 via Wikimedia Commons. Riverview Homes, Inc., CC by SAW 3.0 https://creativecommons.org/licenses/ by SAW divided by 3.0 via Wikimedia Commons. Here are some examples of stick-built homes, including one under construction. Learning objective. Identify different types of freehold estates. Estates in real property. The amount and kind of interest that a person has in real property is called an estate in land. An estate may be defined as the degree, quantity, nature, and extent of interest one has in real property. Estates in land are divided into two major classifications: non-freehold estates or leasehold estates and freehold estates. Freehold estates and interests in North Carolina. Freehold estates are estates of indeterminable length of ownership, such as those existing for a lifetime or forever. Freehold estates are passed from grantor to grantee via the deed when title to real estate is conveyed. The types of freehold estates that can be transferred include fee simple estate, the feasible fee estate, per order vie estate with remainder or reversion, and ordinary conventional life estate with remainder or reversion. The first three of these estates continue for an indefinite period and are inheritable by the heirs of the owner. They are called estates of inheritance. The fourth terminates on the death of the named person on whose life the estates are based, called the measuring life. They are called estates not of inheritance. Non-freehold or leasehold estates, which will be discussed thoroughly in Unit 11, include any estate that is not a freehold estate. A leasehold estate exists on property in addition to a freehold estate when the property owner has rented the property to a tenant. The four types of leasehold estates are the estate for years, estate from year to year, estate at will, and estate at sufferance. Fee simple estate. A holder of an estate in fee simple is entitled to all rights in the property. An estate in fee simple is the highest type of interest in real estate recognized by law. It is complete ownership. This estate is of potentially unlimited duration. When the owner dies, the estate passes to the owner's heirs or divisies. A fee simple estate is an estate of inheritance and is always legally transferable, but it is not always free of encumbrances. There are two major types of fee simple estates: fee simple absolute, that basically has no ownership limitation, and fee simple defeasible, where the ownership can be terminated due to the actions of the current owner. Fee simple absolute. A fee simple ownership on which there are no limitations is a fee simple absolute estate. In common usage, the terms fee and fee simple are used interchangeably with fee simple absolute. Owners of a fee simple estate can do whatever they wish with the property, as long as the use does not violate public land use regulations, deed restrictions, or the rights of others. This is the highest form of land ownership and is the type of estate conveyed via the deed in most real estate transactions. Fee simple defeasible. A fee simple defeasible estate may be lost on the occurrence or non-occurrence of a specified event. Also known as a qualified fee estate, the new owner must stay qualified to own the estate by obeying deed restrictions imposed on the estate by a previous owner. Whether the restriction prohibits an activity or requires a specified land use will dictate which type of defeasible fee estate has been granted. Two types of defeasible estates are fee simple subject to a condition subsequent and fee simple determinable. A fee simple subject to a condition subsequent estate dictates some action or activity that the new owner must not perform. The former owner retains a right of re-entry called a reversionary right, so that if the condition is broken, the former owner can retake possession of the property through court proceedings. A fee simple estate with condition subsequent does not automatically revert to the original owner. Example: a grantor that deeds his land with the deed condition that there be no sale of alcohol on the premises is a fee simple subject to a condition subsequent. If alcohol is sold on the property, the former owner has the right to require full ownership. It will be necessary for the grantor to go to court to assert that right. There is no automatic right of reversion. A fee simple determinable estate requires that a specified activity or land use continue. In a fee simple determinable estate, the ownership is held so long as or during the period the condition or limitation is maintained. The former owners, their heirs, or their successors retain the right of reversion that automatically requires full ownership if the special condition ceases to exist. No lawsuit is necessary for reversion. The use of the land has been predetermined and the penalty for noncompliance has been predetermined. Example: when an owner grants land as a gift to a church, so long as the land is used only for religious purposes, it is known as a fee simple determinable. The church has the full bundle of rights in the property the grantor, owner had, including ownership, with the exception of one of the sticks in the bundle known as the control stick in this case. If the church ever decides to use the land for a non-religious purpose, the property automatically reverts back to the owner who granted the land as a gift, or that owner's heir. A real estate broker is strongly encouraged to have competent legal advice when encountering any qualified estate scenario, as only attorneys can create or interpret these types of estates. Because they will take effect only at some time in the future, the right of re-entry and the possibility of reversion are called future interests. Life estate. A life estate is a freehold estate in land that is limited in duration to the life of the new owner or to the life or lives of some other designated person or persons. This form of ownership is occasionally called a partial estate because it does not last forever. Conventional life estate. A conventional life estate is created by grant from the current owner of the fee simple estate. The current owner retains a reversionary interest in the property or names a remainderman that will ultimately receive fee simple absolute title. A conventional life estate is limited to the lifetime of the new owner of the life estate. An ordinary life estate ends with the death of the person to whom it was granted. It is possible to have successive life estates. Remainder interest. Reversionary interest. Example: ultimately, a man wants his children to have ownership of a piece of property, but he wants his mother to be able to own it for as long as she lives, so he deeds the property to his mother for her life. A man's mother is the life tenant, with her life being the measurement for how long she will own the estate. His children are the remainder men. When she dies, the ownership of the property will automatically transfer to his children, who will then have a fee simple absolute estate. When someone dies without a will, or dies with a will disinheriting a spouse, or leaving him or her very little, North Carolina allows the surviving spouse to choose an elective share of the estate instead. This share is sometimes referred to as a marital life estate. As of October 1st, 2013, the determination of the percentage to which a surviving spouse in North Carolina is entitled was changed to a length of marriage approach. Life estate per Otter Vi. There is also an estate known as an estate for the life of another, the legal term being life estate per Otter Vi. As with a conventional life estate, the life tenant owns the property. In this estate, it is owned for the lifetime of some named third party called the measuring life. The measuring life has no present or future ownership in the property, and only serves as the yardstick for the term of the life tenant's ownership. Upon the death of the measuring life, the estate would either revert to the original owner or become the property of the named remainderman. If the life tenant should die before the measuring life, the heirs of the deceased life tenant will inherit the life estate either by will or by descent. Example: Austin owns fee simple title to a property. He conveys a life estate to his brother Carl for the life of Carl's daughter, who has a major disability. Carl has the right to enjoy the ownership of the property and is the life tenant, but the daughter is the measuring life. Should the daughter die, Carl's estate will terminate and revert to Austin or Austin's heirs. The daughter has no present or future ownership interest in the property. While a conventional life estate is not considered an estate of inheritance, a life estate per Otter Vi can be inherited by the life tenant's heirs, but only until the death of the measuring life. For example, if Carl died before his daughter, she and any other of Carl's heirs would inherit the life estate. However, the inherited life estate would terminate on the death of the daughter. Remainder and reversion. A fee simple owner who creates a life estate must consider the future ownership of the property after the termination of the life estate. The future interest may take one of two forms. Remainder interest. The grantor names someone other than the grantor to receive title to the property when the life estate terminates. This occurred in our example when a man provided that his children would receive title and a fee simple absolute estate once his mother's life estate terminated. The person named is said to own a remainder interest and is called a remainderman. A remainder interest is a non-possessory estate of future interest. This interest can be sold. Reversionary interest. If the grantor does not name a remainderman, then ownership returns to the grantor when the life estate terminates. This is called a reversionary interest. If the grantor is deceased when the life estate terminates, the property goes to the grantor's heirs or devisees. This interest or estate is called a reversion and is also a future interest. When the life estate terminates, the holder of the future interest will be the owner of a fee simple absolute estate. Rights of life tenants. A life tenant's interest in real property is a true ownership interest. In general, the life tenant is not answerable to the holder of the future interest as long as the property is maintained. A life tenant is entitled to all income and profits arising from the property during the life tenancy, and typically is obligated to pay the property taxes and maintain homeowners insurance. A life tenant also may use some of the property's resources to maintain the property. For example, a life tenant may sell some of the timber growing on the property to pay for damages caused by a flood. This right to use property resources is referred to as assestovers. A life tenant also can sell or mortgage a life tenancy, although there may be few parties willing to purchase or lend money that is secured by such a limited interest. Life tenants must pay real estate ad valorem taxes and special assessments that arise during the tenancy. They must also pay the interest, but not the principal, on any pre-existing debt secured by the property. A life tenant's rights are not absolute, however. A life tenant can enjoy the rights of the land but cannot encroach on those of the reversioner or remainderman. In other words, the life tenant cannot perform any act that would permanently injure the land or property. For example, a life tenant would not be allowed to destroy an orchard on the property to avoid having to bother with it. This kind of injury to real estate is known in legal terms as waste. Those with a future interest in the property could bring legal action for damages or seek an injunction against the life tenant. Tax advantages. Why would property owners consider conveying property in a life estate? A transfer of real estate from individual or joint ownership to a life estate form of ownership may be an estate planning device used to avoid probate of the property. Transfer to life estate ownership may avoid some of the disadvantages of an outright gift of the property to the heirs. Real estate brokers should refrain, however, from advising consumers about legal or tax consequences of holding or conveying title and defer these concerns to the appropriate advisors. A homestead is a legal life estate in real estate occupied as the family home. In effect, the home is protected from most creditors during the occupant's lifetime. In states that have homestead exemption laws, a portion of the acreage or value of the property occupied as the family home is exempt from certain judgments for debts, such as charge accounts and personal loans. A homestead is not protected from real estate taxes billed against the property, or a mortgage for the purchase or cost of improvements. That is, if the debt is secured by the property cannot be exempt from a judgment on that debt. In some states, all that is required to establish a homestead is for the head of a household to own or lease the premises occupied as a primary residence. In other states, the owner is required by statute to file a notice of homestead rights. A family can have only one homestead at any given time. In most states, the homestead exemption merely reserves a certain amount of money for the household in the event of a court sale. In a few states, however, the entire homestead is protected from sale altogether. Once the sale occurs, any debts secured by the home will be paid from the proceeds. Then the household will receive the amount reserved by the homestead exemption. Whatever remains will be applied to the household's unsecured debts. Learning objective. Distinguish between forms of concurrent and common interest community ownership. Ownership of real property. Freehold estates define what rights are being conveyed with the real estate. Ownership of real estate defines who will hold the title and what form the ownership will take. Ownership may be held in severalty, which means that title is held by one owner, or co-ownership, co-tenancy, or concurrent ownership, where title is held by two or more persons at the same time. The form of ownership will be noted in the purchase contract and then used in the deed to convey the property from the current owner to the new owner or owners. The manner in which the property title is held is important to the real estate broker for two reasons. The form of ownership existing when a property is sold determines who must sign the various documents involved, and the purchaser must determine in what form to take title. For example, a sole purchaser generally takes title in the purchaser's name alone, and a tenancy in severalty is created. However, if there are two or more purchasers, they may take title in a tenancy in common, in joint tenancy, or in tenancy by the entirety. When questions about these forms of ownership are raised by the parties to a transaction, the real estate broker should recommend that the parties seek legal and tax advice. Ownership in severalty. When title to real estate is vested in one person or a single entity, such as a corporation or limited liability company, that person or entity is said to own the property in severalty. This person or entity is also referred to as the sole owner. Concurrent ownership. When title to one parcel of real estate is vested in two or more persons or entities, those parties are said to be concurrent owners or co-owners of the property. An important aspect to concurrent ownership is the unity of possession, which means no one owner may possess a portion of the property and not allow access to the other owners. For example, owner A cannot build a fence down the middle of the property and keep owners B and C from entering that side of the property. All owners have equal rights to all the property. There are several forms of co-ownership, each having unique legal characteristics. The three forms of concurrent ownership are tenancy in common, joint tenancy, and tenancy by the entirety. Tenancy in common. A parcel of real estate may be owned by two or more people, entities, in what is known as a tenancy in common. An important characteristic of tenancy in common is that while co-owners have unity of possession, they may have unequal shares. This means that although a tenant in common may hold, for example, a 1/2 or 1/3 share in a property, it is impossible to distinguish physically which specific half or third of the property the tenant in common owns. The deed creating a tenancy in common may or may not state the fractional shares held by each co-owner. If no fractions are stated, the tenants are presumed to hold equal shares. For example, if 5 people hold title, each would own an undivided 1/5 share. Although ownership shares are frequently equal, it is not a requirement of this type of ownership. The second important characteristic of a tenancy in common is that each owner holds an undivided interest in severalty, and can sell, convey, mortgage, or transfer that interest through the right of partition. On the death of a co-owner, that tenant's undivided interest passes to the heirs through a probate proceeding. The interest of a deceased tenant in common does not pass to another co-owner tenant in common unless the surviving co-owner is an heir in the deceased owner's will or is purchasing the deceased owner's share. Tenancy in common. In states that do not recognize tenancy by the entirety, when two or more people acquire title to a parcel of real estate and the deed does not stipulate the type of tenancy created, by operation of law, they acquire title as tenants in common. In states that recognize tenancy by the entirety, this would only apply if the parties taking title were unmarried. Joint tenancy. Most states recognize some form of joint tenancy in property owned by two or more people. With joint tenancy, the ownership shares are usually required to be equal. A main feature that distinguishes joint tenancy from tenancy in common is the right of survivorship. With survivorship, the death of one of the joint tenants does not destroy the ownership unit. It only reduces by one the number of people who hold title to the property. As each successive joint tenant dies, the surviving joint tenant will acquire the interest of the deceased joint tenant. The joint tenancy continues until there is only one owner, who then holds title in severalty. The last surviving joint tenant has the same rights to dispose of the property as any sole owner. This type of ownership also requires that the joint tenants have equal possession, equal interests, and that title be taken at the same time. This means all owners have unity of possession, all ownership shares are equal, title to the property was taken together at the same time, and names of all joint tenants appear on the deed. If property is owned by three or more joint tenants and one conveys interest to an outside party, the new owner will hold interest as a tenant in common with the remaining joint tenants. The original remaining joint tenants will still hold their undivided interests as joint tenants among themselves. Joint tenancy with right of survivorship. Unlike other states, North Carolina does not favor the right of survivorship for a joint tenancy. In 2009, the language in North Carolina General Statute 41-2 and was changed to allow unequal ownership interests, if so desired. In North Carolina, joint tenancy interests will be presumed to be equal unless clearly marked as unequal. The right of survivorship can be created if the deed is worded in exact compliance with North Carolina court decisions, making it clear that the right of survivorship is intended. Otherwise, North Carolina statutes provide that on the death of a joint tenant, the decedent's estate does not pass to the surviving joint tenant, but instead goes to the heirs in the same manner as estates held by tenancy in common. In other words, unless the deed is worded exactly right, a joint tenancy can be created, but the right of survivorship does not apply. Note that where a right of survivorship is created, if one joint tenant owner conveys an interest to another person, the new owner has no right of survivorship with the other owners. The new owner becomes a tenant in common with the other owners because title is conveyed at a separate time. Combination of tenancies. A lawyer should always be consulted if the parties to a transaction insist on the right of survivorship. There are many technical requirements that must be met before a North Carolina court will recognize a joint tenancy with a right to survivorship. Termination of tenants in common and joint tenancy co-ownership by partition suit. Each co-owner of real estate has an absolute right to force a partition of the land by voluntary action. An agreement, which will divide a co-owner's real estate according to his or her interests. When a division among co-owners cannot be agreed on voluntarily, the division can be ordered by a court in a suit for partition. The court may actually divide the land into pro rata parcels, or, if this cannot be done, may order the property sold and the proceeds divided proportionately among the owners. Tenancy by the entirety. Tenancy by the entirety is a special form of tenancy used in many states in which the owners must be spouses. Each spouse has an equal, undivided interest in the property. Each, in essence, owns the entire estate. On the death of one spouse, full title automatically passes to the surviving spouse through the right of survivorship without a probate hearing. The transfer of the interest of the deceased spouse may be recorded by filing a certificate of death, an affidavit, or a certificate of transfer, as provided by law. The distinguishing characteristics of tenancy by the entirety are the following. The owners must be spouses when title is received. The owners have rights of survivorship. During the owners' lives, title can be conveyed only by a deed signed by both parties. There is generally no right to partition. In North Carolina, any conveyance to spouses by deed or by will creates a tenancy by the entirety by default unless specifically stated otherwise. A tenancy by the entirety may be terminated by the death of either spouse, divorce, or the mutual agreement of both spouses. Note that spouses can choose another form of ownership for property that is owned during marriage. Tenancy by the entirety is not the only available option. Tenants in common or joint tenancy can be used. Furthermore, property that is jointly owned before marriage does not automatically become a tenancy by the entirety simply by virtue of the fact of marriage. If a couple owned property before marriage as tenants in common, they will continue to own the property as tenants in common unless the spouses choose to legally change the form of ownership. On June 27, 2015, the U.S. Supreme Court ruled that gay marriages are legal across the country. Attorneys advise that such couples who now own real property as joint tenants and who marry should red idle their property as tenants by the entirety. Red idling involves preparing and recording a new deed, a relatively simple matter that may even be exempt from transfer, and recordation taxes. Until this court decision, the next best form of concurrent ownership for unmarried partners was joint tenancy with rights of survivorship. Not only are entireties superior to joint tenancy because of the attribute of automatic survivorship, claims of one owner's creditors do not attach to the real property owned by the tenancy by the entirety. Common interest community ownership. Some forms of ownership are called common interest community ownerships because they contain elements of both ownership and severalty, and concurrent ownership. Owners of individual units may hold title to their unit in any legal way previously discussed. The owners of the individual units must also legally support the maintenance of the common areas through membership in a homeowners association and payment of periodic dues. While many common interest communities are residential in use, this ownership model is increasing in popularity for commercial uses. Condominium ownership. Condominium ownership started with apartment buildings in Europe before gaining wide acceptance in the United States. Condominium laws, often called Common Interest Ownership Acts or Horizontal Property Acts, have been enacted in every state, including North Carolina. Under these laws, the occupant, owner of each unit holds a fee simple absolute title to the unit. Each unit owner also owns a share of the common elements, such as the pool, hallways, and other amenities. These elements are owned and held by the unit owner as a tenant in common with the other unit owners in the complex. The individual unit owners in a condominium own and use these common elements together as tenants in common. The individual unit owners pay their own separate property taxes and mortgage payments and typically belong to an owners association that manages the common elements of the condominium complex and determines the homeowners association dues or fees. These fees are used to maintain the common elements and establish reserves to pay for upkeep of the common elements. Condominiums are created by declarations that determine which spaces will be individual unit ownership and which are common elements, as well as how the HOA will be structured and how dues and fees will be set. Condominium ownership. The condominium form of ownership may be used in any type of real estate. The most typical type of real estate is residential, but office, warehouse, and mixed-use spaces may also use this form of ownership. It is usually used for apartment buildings. These may range from freestanding high-rise buildings to townhouse-like arrangements. The common elements include such items as the land, exterior structure, hallways, elevators, stairways, and roof. In some instances, lawns and recreational facilities such as swimming pools, clubhouses, tennis courts, and golf courses also may be considered common areas. In addition, the condominium form of ownership is used for other types of properties such as commercial properties, office buildings, and multi-use buildings that contain offices and shops, as well as residential units. Some condominium projects offer a special type of common elements that is reserved for the use of only one or more units to the exclusion of the other units. Assigned storage areas or parking spaces would be examples of limited common elements. Creation of a condominium. The North Carolina Condominium Act of 1986 specifies that a condominium is created and established when the developer of the property executes and records a declaration of its creation in the county where the property is located. The declaration must include any covenants, conditions, or restrictions on the use of the property. The developer must file a plat map or plan of the condominium property, buildings, and any other improvements. The developer also must prepare a set of bylaws. The bylaws usually provide for the creation of a unit owners association giving a vote to each unit owner, the election of a board of managers from among the unit owners, the duties of the board of managers, the compensation of its members, their method of election and removal, whether a professional manager is to be engaged, and the method of collecting the unit owners association monthly dues from each member to cover the costs of management and maintenance of the common areas. Consumer protection. The North Carolina law also requires disclosure and other consumer protection measures in connection with new residential condominium unit sales in the form of public offering statements. The developer must disclose all ownership and other appropriate documents to the purchaser before the purchase contract is signed. The purchaser then has a 7-day rescission period, which begins after the purchase contract is signed. At any time during that 7-day period, the purchaser can cancel the sale and receive a full refund of any monies paid. On a resale unit, a resale certificate detailing the monthly dues assessment and any other fees payable by a unit owner must be given to a purchaser prior to conveyance. There is no right to cancel in resale transactions. Watch the video to learn more about condominium ownership. Cooperative ownership. Under the usual cooperative ownership, title to land and building is held by a corporation. The building management sets a price for stock shares for each unit in the building. Each tenant of a unit in the building purchases stock in the corporation when the tenant pays the agreed-on price for use of a specific apartment. The purchaser then becomes a shareholder of the corporation and, by virtue of that stock ownership, receives a proprietary lease to the unit for the life of the corporation. There is no deed because there is no ownership of the individual unit. The cooperative building's real estate taxes are assessed against the corporation as owner. Generally, the mortgage is signed by the corporation, creating one lien on the entire parcel of real estate. Taxes, mortgage interest, and principal, plus operating and maintenance expenses, are shared by the tenants, shareholders in the form of monthly assessments. While the cooperative tenants, owners do not actually own an interest in real estate, for all practical purposes, they control the property through their stock ownership and their voice in the management of the corporation. The bylaws of the corporation generally provide that each prospective purchaser of an apartment lease must be approved by an administrative board. This hybrid form of ownership has not enjoyed much popularity in North Carolina to date. Townhouse ownership. Townhouse projects are typically a group of 2-story or 3-story units that are horizontally attached to each other. That is, they share party walls and are sometimes called row houses. Each townhouse unit is individually owned. All unit owners have membership in the homeowner association that owns the common areas. The homeowners association will pay real property taxes on the common areas, while each individual unit owner will pay the real property taxes on the unit the individual owns. Townhouse ownership is similar to condominium ownership with one fundamental difference. The owner of each townhouse unit also owns the land on which that unit is built. To summarize the differences between condos and townhomes, condo unit owners own the inside of their units. Townhouse owners own the complete unit, including exterior surfaces, and the land on which the unit is built. Every condo or townhouse development also has common areas of the property such as recreation areas, sidewalks, and parking lots. Condo owners share ownership of the common areas with other owners, while common areas in townhouse developments are usually owned by the homeowners association for the benefit and use of unit owners. Either way, owners typically pay dues to a homeowners association to cover the costs of maintaining the common areas, as well as other common expenses. Townhouse communities in North Carolina are regulated under the North Carolina Planned Community Act. Timeshare ownership. A timeshare ownership is any right to occupy a unit of real property during 5 or more separated time periods over a period of at least 5 years. Time sharing permits multiple purchasers to buy interests in real estate, usually a unit of a resort hotel, an apartment, or a condominium, with each purchaser having a right to use the facility for a specific time period. For instance, a timeshare owner may have the right to use an oceanfront apartment for the first 3 weeks of June every calendar year. Due in large part to the historically high-pressure sales practices associated with the sale of timeshares, the North Carolina Timeshare Act was passed to regulate the development and sale of timeshares. Despite the name given to a development project, if the format meets the definition in the Act, it will be classified as a timeshare and subject to its requirements. For example, all timeshare projects must be registered with the state. All developers selling or offering to sell timeshares must renew their registrations on or before June 30th of each year. Developers must give prospective purchasers public offering statements prior to contract, and purchasers have a 5-day cancellation or rescission period during which they can cancel the purchase without penalty. Any payments received by a timeshare developer or broker must be deposited in a trust or escrow account in an insured bank or savings and loan in North Carolina and remain in such account for 10 days or upon cancellation by the purchaser, whichever occurs first. Timeshare salespeople must be active real estate brokers operating under a project broker who are subject to disciplinary action by the North Carolina Real Estate Commission. There is no separate license for individuals selling timeshares. Individuals who sell timeshares must be properly licensed North Carolina brokers. The Commission can also fine unlicensed timeshare developers $500 for each violation of the Act or revoke the project's registration certificate. Learning objective. Describe the purpose in different types of trusts. Trusts. In recent years, trusts have been using major estate planning tools to limit the time and cost of probate. Probate is a legal process that takes place after someone dies and can be quite costly to the heirs. Probate involves proving in court that a deceased person's will is valid, identifying and inventorying the deceased person's property, having the property appraised, paying debts and taxes, and distributing the remaining property as the will directs. If individuals put their assets in a trust, those assets may be able to pass to the heirs outside of probate, not only saving time and money but also potentially reducing estate taxes. Creating a trust allows individuals to specify the terms of the trust precisely, controlling when and to whom distribution is made. They may also, for example, set up a revocable trust so that the trust assets remain accessible to them during their lifetimes while designating to whom the remaining assets will pass thereafter, even when there are complex situations such as children from more than one marriage. A properly created trust can help protect an estate from heirs' creditors, or from beneficiaries who may not be adept at money management. Another advantage of trusts is that while probate is a matter of public record, a trust may allow assets to pass outside of probate and remain private. A trust is a fiduciary arrangement that allows a third party, or trustee, to hold assets on behalf of a beneficiary or beneficiaries. Trusts can be arranged in many ways and can specify exactly how and when the assets pass to the beneficiaries. A trust is a means by which one party transfers ownership of property to another party, or parties, to hold or manage for the benefit of a third party. The truster is the individual who creates the trust. The beneficiary is the person or entity that benefits from the trust. The trustee is the fiduciary who exercises control over the subject property to the instructions of the truster in the trust agreement. A trustee can be a bank, attorney, or other entity set up for this purpose. Sometimes the trustee is the same individual as the truster. The trustee's power and authority is limited by the terms of the trust agreement in law, but typically the job of the trustee is to take care of the trust's assets. After payment of trust expenses and trustee's fee, income may be paid to or used on behalf of the beneficiary. The trustee may be able to transfer assets into and out of the trust per trust agreement terms. Some trusts may own or hold real property. For example, living trusts which are created during the truster's lifetime may hold real property. Other illustrations include testamentary trusts, land trusts, and real estate investment trusts. Land trusts are sometimes used to keep the identity of the property owner private since public records do not usually name the beneficiary. A land trust beneficiary is usually the truster. The beneficial interest in the trust is considered personal property that may be transferred by assignment versus a deed. A land trust usually has a definite term, which can be extended. Assets transfer to the beneficiary upon specified terms of the trust agreement. Trust dissolution may occur when the beneficiary reaches a certain age, at the death of the beneficiary or the trustor, or when other conditions are met. Legal and tax implications for trusts are complex and vary widely. Real estate practitioners must be careful in dealing with individuals whose real estate assets are held by a trust. Sometimes beneficiaries contact real estate agents indicating that they want to sell those assets, when in fact, the disposition of those assets are likely to be in control of the trustee. As a result, real estate professionals should be dealing with the trustees, and not the beneficiaries regarding the possible disposition of the asset. It would be best to involve competent legal advisors in any transaction involving real estate held in a trust. Key point review. Bundle of legal rights includes the right of disposition, right to enjoyment, right of exclusion, right of possession, and right of control. Appurtenance is a right or privilege associated with real property that normally transfers along with the property to the new owner when the property is sold. An appurtenance could include such rights as an improvement to the property like a building or a parking space in a multi-unit building, an easement, or water rights. Real estate is the earth's surface where water rights are held by owners of land adjacent to rivers, lakes, or oceans. Extends downward to the center of the earth, where subsurface rights include mineral rights and other natural resources that can be transferred separately from surface rights. Stretches upward to infinity, where air rights can be sold separately from surface rights with some limitations to enable air travel, and includes things naturally attached to the land, such as trees and crops that do not need cultivation and perennial crops, orchards, and vineyards fructus industriales. Water rights are determined by common law and statute. Riparian rights are common law rights granted to owners of land along rivers, streams, or similar bodies of water. Littoral rights belong to owners of land that borders commercially navigable lakes, seas, and oceans. Personal property includes movable items such as a chair or a sofa, emblements, annual plantings or crops of grains, vegetables, and fruit. Items of real property that can become personal property by severance. Items of personal property that can become real property by attachment or annexation. And manufactured homes that are personal property until permanently affixed to land. A fixture is personal property that has been affixed to the land or to a building so that by law it becomes part of the real property. Modular homes immediately become part of the real estate. Fructus naturals are considered real property. Legal tests for a fixture include the following. Intent of annexer, was it meant to go or stay? Relationship of annexer, owner or tenant. Method of annexation, not easily removable. Adaptation to real estate, ordinarily considered a permanent addition. Trade fixtures include property attached to the structure but used in the course of business. Personal property if removed by tenant and the premises are returned to original condition before the lease expires. And real property if left behind by tenant. A landlord can acquire this type of property by accession. Agricultural fixtures, improvements made to North Carolina farms by tenants' farmers, become real property. Per the Uniform Commercial Code, an item bought on credit remains personal property until paid for, and a creditor can repossess the item in event of default. A freehold estate lasts for an indeterminable length of time. Fee simple is the highest estate recognized by law. Fee simple defeasible is a qualified estate. Fee simple subject to a condition subsequent is a non-occurrence of some specified event. Fee simple determinable is automatic ownership reversion if specified action stops. Per honor vie estate is based on the lifetime of another person. Life estate is based on the lifetime of owner. When a spouse dies intestate, the surviving spouse may receive an elective share, also known as a marital life estate. Ownership in severalty, title held by one individual, entity which may be a single individual or an artificial person, such as a corporation, has the following characteristics. Sole rights to ownership. Sole discretion to transfer part or all ownership rights to another person. Concurrent ownership, title held by two or more individuals, may be one of three forms: tenancy in common, joint tenancy, or tenancy by the entirety. Tenancy in common is where each tenant holds an undivided fractional interest. Co-owners have unity of possession, right to occupy entire property. Each interest can be sold, conveyed, mortgaged, or transferred, and interest passes by will when a co-owner dies and right of survivorship not possible. Joint tenancy is where tenants enjoy the following four unities. Unity of possession, all joint tenants have undivided right to possession. Unity of interest, all joint tenants usually own an equal interest. Unity of time, all joint tenants acquire their interest at the same time. Unity of title, title is conveyed to all joint tenants by the same document. Joint tenants usually enjoy the right of survivorship. Upon the death of a joint tenant, interest passes to the other joint tenant or tenants. In North Carolina, joint tenancy ownership can have unequal interests and is created without right of survivorship, unless there is specific wording in the deed to include the right of survivorship. Termination of joint tenancy is by death of all but one joint tenant, who then owns the property in severalty. Conveyance of a joint tenant's interest, but only as to that interest, or partition, which can be brought to forced division or sale of property. Tenancy by the entirety, recognized by North Carolina, has the following characteristics: only available to spouses. Title conveyed only by deed signed by both. Carries right of survivorship. Common interest community ownerships include condominium, townhouse, cooperative, and timeshare ownerships. Condominium laws of each state define the following. The condominium owner holds fee simple title to the airspace of a unit as well as an undivided share in the remainder of the building and land, known as the common elements. Common elements are owned by condominium unit owners as tenants in common. Limited common elements refer to assigned amenities, such as storage lockers, bins, and car storage. The condominium is administered by an owners' association of unit owners that may decide to hire an outside property management firm. Maintenance of common elements is funded by fees charged to each unit owner. Unit owners have no right to partition common elements. Condominium units may be mortgaged. Default on payment does not affect other unit owners. North Carolina Condominium Act of 1986 requires disclosures and allows 7-day rescission on purchase of new units. In a cooperative, title to the land in the building is held by a corporation, which sells shares of stock to prospective tenants. A purchaser of stock becomes a shareholder in the corporation and receives a proprietary lease to the apartment for the life of the corporation. Stock is owned as personal property and not real estate. The lender may accept stock as collateral for financing, which expands the pool of potential owners. The IRS treats a cooperative the same as houses or condominiums for tax purposes. In a townhouse, a horizontal form of ownership in which houses share common vertical walls, titles to individual units include a fractional interest in common areas. Some land is owned by the individual unit owner and is not part of the common area. The common areas are owned by the townhouse HOA. A timeshare permits the sale of a leasehold interest or deeded ownership that allows occupancy during a specific period of time, typically weekly. Timeshare transactions are governed by the North Carolina Timeshare Act. Timeshare ownership permits multiple purchasers to buy interests. In real estate, a form of ownership most commonly found with resort property. With the North Carolina Timeshare Act, there must be at least 5 separated periods of use over at least 5 years. The buyer has a 5-day right of rescission. Any deposits must be held in trust for at least 10 days to allow for receipt of rescission notice. NCREC can fine a timeshare developer $500 per violation of the act. And the timeshare salespeople must be actively licensed real estate brokers. A trust is a fiduciary arrangement that allows a third party or trustee to hold assets, such as real estate, on behalf of a beneficiary.